Yes, thank you both for the very helpful arguments for this morning, which I have read. And that being so, it seems to me that this is quite a narrow issue and the scope for oral argument is not great. So if you'll forgive me, I'm going to give you a guillotine of 20 minutes each and 5 minutes for reply.
Lord, yes. Can I deal briefly with the procedural point taken against me, which is this is a CPR 5282 application?
Yeah.
That there are two separate regimes for imposing conditions. The first is 52.6, that's White Book, page 1843, which enables the court to impose conditions. That rule contains at the end of it a cross-reference back to CPR 25.15. That's a not merely an editorial note, it's part of the rule. So we see from that the court can, by way of a condition, impose a requirement on security costs provided. White Book, current White Book.
Yeah, well, I'm not on the current White Book, so don't worry about that. We don't have up-to-date White Books in court anymore, but never mind. It's the rules that matter. So,
52.6, my lord.
Yeah.
So at the end of 52.6, there's a cross-reference back to Rule 25.15.
Yeah.
So I say that the court can impose as a condition of granting permission the provision of security. Now there's a second provision, which is 52.18, which empowers the court to impose conditions after permission has been granted. And we see from the notes in what's page 1869 in the current White Book, that's immediately after the rule, that enables conditions to be imposed when such conditions were not attached to the original grant of permission. Now in our case, our 52C paragraph 19 statement raised the question of security. And my Lord's order...
Sorry, I'm struggling to follow the point you just made about it being after the grant of permission.
Yes, 52.18, my Lord, which is page 1867 of the current White Book. Yeah. And the editors of the White Book point out in what's currently current edition of the White Book, top of page 1867, following on immediately from the rule. So Rule 52.18 has a note.
Yeah. It says enables conditions to be imposed where they were not attached to the original grant of permission, yes. But it doesn't mean to say that it's restricted to that, does it?
No, it isn't. It isn't. But the point I'm driving at is that the cross-reference one sees to 25.15 in Rule 52.6 means that the drafting of 52.6 assumes that when considering whether to impose a condition of requiring security for costs, the test is the Part 25 test. And that's because 25.15 says in terms that an appeal court can order security for costs against an appellant in the same way a first instance court orders security for costs against a claimant. So my learned friend says, well, that the test under 52.6 is compelling reasons by reference to Paladin. And that, of course, was a case where security wasn't sought. It was a case where what was sought was security in respect of the judgment sum.
It was payment of the
part of the judgment sum into court.
Yeah.
Now, what I suggest is that
security for the debt is a bit different to security for costs.
That's the point I was about to make, Lord, that they are different, and that the way the drafting of 52.3 proceeds is that security for costs can be ordered on the 25.15 test, and I don't need to show compelling reasons. That's a pure point of construction of the rules. But if necessary, I do say there would be compelling reasons. Now, I'm sure the rules for granting security for costs against persons non-resident in Hague Convention countries will be exceedingly familiar, but I do say that Bezimov contains a useful summary, and in particular provides support for the proposition that what one is looking for is a real risk of substantial obstacles to enforcement.
Yeah.
That's the test, and really everything else is noise. That's the question.
Yeah.
Now, we said there is a real risk. My law will have seen that there was an application for security for costs before before Judge Briggs. That included Miss London's report, to which there's never been an answer, which identifies a whole series of difficulties that will be faced in seeking to enforce. I'm not going to go through that, but I say that that provides a proper evidential foundation for the contention there is a real risk of substantial obstacles. Now, I turn now to the points taken against me. These appear to be either intended to say there's no risk of non-payment, or to say that there are discretionary factors. But, and this is an important point, all of these proceed on the basis that one is investigating whether there is a real risk of non-voluntary payment by the applicant. And that, I suggest, is not the test. One is not inquiring into whether or not there is a real risk of the appellant not voluntarily paying. One assumes that and asks instead whether there is a real risk of substantial obstacles to enforcement in the place of residence of the appellant. Now, dealing with the points briskly, the first head of points taken against me is to say there's no risk of non-payment. It said there are no outstanding cost orders against the trustee. That's not, of course, correct. There's been a payment on account ordered in respect of a liability under Mr. Morgan's order. That assessment has not yet been concluded and is likely to result in a substantial sum becoming due. Next, it said, and this is Mr. Beckwith's statement, paragraph 9, that the Russian court has sanctioned the use of monies in the estate to fund the English proceedings. That's hearsay. We don't have the order or the judgment. And in any event, it appears to be, even on its own terms, a mere sanction, not a requirement to pay, still less an acknowledgement the Russian trust ought to pay. And it's very difficult to square with the position in respect of Elwy, the Russian lawyers, whom I'm going to come back to right at the end, as they're important. But the short point there is that Mr. Beckwith says that the source of the 40,000 used to pay Mr. Morgan's costs order, and account order, was Elwy's own funds. That was paid last month. But if in December, a month earlier, there'd been permission to use the funds in the estate to meet the costs order, it doesn't really make much sense for Elwy to be using its funds to do that. Next, discretionary factors prayed against me. First, it said, well, the respondents are in some way associated with the bankrupt. Short point there is they say the bankruptcy shouldn't be recognised, that they are not bound by the decision of Judge Briggs, which in any event they're seeking to appeal. And they also say that the Eurasia shares, which is the only reason the Russian trustee is in England, are beneficially theirs. So even if it's right that the bankruptcy is to be recognised, the asset in question doesn't vest in the estate. My Lord can't possibly get into those kind of hot contested issues today. Secondly, it said, well, we opposed the appellant's application to the Russian bankruptcy court for authority to have recourse to the estate. Now, the reference given for that is a letter. It's bundle 2, tab 19, page 489. I won't invite my Lord to read it, but I do say it doesn't support that contention. If one reads the letter, it doesn't say that. Then it said, well, we sought security for costs before Judge Briggs. Indeed, we did. The short point there is a claim was being brought against us seeking to vindicate title to the shares. We understood the procedural framework in which that was to be contested was the recognition application. We sought security. Now, the upshot of the hearing before Judge Briggs was to push all those questions off into the Eurasia action to be tried in a conventional action in the Chancery Division. So we'll be seeking security for costs there, and the fact we sought security for costs earlier is neither here nor there. Then it said, well, recognition is a summary procedure. That's not really relevant. Anyway, it's not really right. In the same way as when somebody seeks to enforce a judgment of common law, there may not be a triable issue, so there may be summary judgment. Equally, there may not. There may have to be a trial, and we say here there will have to be a trial, so that point doesn't go either. Then it said, well, there's a costs order against the respondents as a result of what Judge Briggs decided. Now, we do say that the decision of Judge Briggs was wrong in principle, not merely about costs, wrong about an important point of principle, and we're seeking to appeal that. But, and this is the rub, the monies we've been ordered to pay on account have been brought into this country and paid into my solicitor's client account. And what we are asking the court to do in our appeal, permission application, is to stay the costs order on terms that those monies are either held to the order of the court or paid into court. So it's not as if we're unable to bring monies in when we need to. We've brought them into the jurisdiction and we are prepared to hold them to the order of the court or pay them into court. And it's wrong also to say that we've refused to pay. Our concern is if we do pay, the monies will be spent and we'll be left having to claim against the trustee, and we're back at the point we started with, which is whether or not there are real obstacles to enforcement. Then it said the underlying proceedings are in some way like an interpleader claim. That's not right, but even if it is right, it's irrelevant, because the point is there's an appeal. The appellant lost at first instance, he comes to the Court of Appeal, and there's jurisdiction to order security for costs against him as an applicant. Then it said, well, the respondents in some way sought to impede or create obstacles. That isn't right either. What we seek to do is defend a claim seeking to vindicate title to property in England on its merits. We say the merits are with us, and we're entitled to defend. And what the trustee's submissions come to is saying, well, I think I've got a good claim, and we say you haven't. And that's not a question the court can get into now. My friend takes a series of points in his skeleton at paragraph 17, and if I can just give my lord very briefly our answers to this. But beginning all of that with a preface that they're all intended to show that there is a real risk of non-payment. As I say, all intended to show there is no risk of non-voluntary payment. But as I suggested earlier, that's not the right question at all. And answering the question my friend poses doesn't help answer the right question. Now, first of all, it said, well, the trustee is a professional trustee and he's confirmed that he'll pay. That's the first and second points. I think the case he relies on, Louis Shu Chung, it doesn't say that a case must be exceptional for security for costs to be ordered against a trustee. Rather, it says that ordering security for costs against a trustee is exceptional. That those are different things, subtly different things. A foreign trustee doesn't enjoy some favoured position. He is in the position of any other person. If the test is satisfied, security for costs ought to be ordered against him. The assurances that have been given are in general terms and are not direct from the trustee. He has not made a statement, still less has he given an undertaking. And the absence of an undertaking is signal. If he came here and said, I'm going to give the court an undertaking personally, that might be one thing. But he's not done that. All he puts forwards are generalised assertions made by his lawyers. There's simply no binding commitment. And this is important, as Miss London points out in her report at paragraph 140, a replacement trustee wouldn't be bound by any personal assurance given by this trustee. So if the creditor's sacked, removed the trustee and appointed somebody else, the new trustee would not be bound. So those assurances are capable of being of no value at all. The next point is to say, well, the 40,000 ordered to be paid was paid. That's in a small sum, comparatively £40,000. And as you'll see in a moment, it came from the funds of Elwy, the Russian law firm. That raises more questions than it answers. But the short point is the trustee had practically no alternative but to pay. If he hadn't done, the application for security would have been irresistible. And the fact he paid that comparatively small sum in circumstances where he had no practical alternative but to pay tells one nothing about the position if he loses the appeal. Then there's an attempt, this is the fourth and ninth points, to treat the respondents as a comparator. Now we suggest that's not a relevant consideration, and in any event it's not right to say that we have some history of defaulting. We've paid the costs ordered to be paid, Eurasian, so much has been made of, and the costs on account under Judge Briggs' orders have, as I say, been brought into this country. Then it said, this is the fifth point, there's authority from the Russian court to pay. I've addressed that, we see. The evidence really doesn't go that far. Sixth point is to say there are assets in the state, in the estate. Those, of course, are in Russia. To get at them, we'd have to go to Russia, and to point to assets outside the jurisdiction necessarily can't assist the trustee's case. All that means is, well, there's money somewhere else, and the question then becomes, well, could we enforce in that place? And we say the answer to that is, well, there is a real risk of substantial obstacles, so that doesn't assist. Then it said, well, the effect of the recognition order is as a vesting of the English assets of the bankrupt in the trustee. That assumes that the recognition order binds anyone. We say it doesn't, because it was made in proceedings to which no one else was a party. By the time that order came to be made, my clients had been discharged from the recognition proceedings under CPR 19, and it was a purely ex parte order made in a piece of litigation to which there was no respondent. Therefore, on conventional principles in relation to declarations, declaratory judgments, it binds no one. We also say it's not capable of operating as an order in rem binding the world. So that doesn't go anywhere. And even if it were right, the entire focus here is on the Eurasia shares. That's the only reason the trustee comes to England at all. And if we're right that they are beneficially our property, they don't vest in the estate. So it doesn't help. Because the entire argument assumes that the shares vest in the estate and are therefore available to meet an adverse costs order. Well, that's one of the hotly contested issues. So that doesn't provide any assurance at all. And then it said that we oppose the use of the monies of the estate. That's the eighth point. That's also wrong. The letter relied on it doesn't make that point good. And if I can deal in 2 or 3 minutes with the final and important point, which is payment methodology. My friend
Which is what?
The payment methodology point.
Right.
My friend Skeleton says in paragraph 20 that the 40,000, and if I can take this slowly, it's quite important, the 40,000 payment to discharge the adverse costs order was made by Elwy, the Russian law firm, with its own funds. I underscore that, with its own funds. Mm-hmm. Now, the reason that was done is that the trustee banks with a sanctioned bank in Russia, and so can't make a transfer himself. Miss London explains that in her report, and it might be worth just turning that up to see how this works. It's tab 22, page 665. It's the second bundle. Tab 22, page 665. This is Miss London dealing with the issues as to payment of costs by a sanctioned bank, CBM. She says in paragraph 115, according to publicly available information, Mr. Vesnin's trustee has an account in PJSC Credit Bank of Moscow as a main bank account of the state. It's designated under the sanctions in the US, the UK, and the EU. And then she goes on to say they've got that bank has no access to SWIFT. That's the international funds transfer system. And so it's effectively shut out of the Western banking system. And so his bank can't make a funds transfer to a Western bank. That's evidence that's never been contradicted and is completely consistent, actually, with the way that the payment of 40,000 came to be made. Now, what's said about that is that it's a payment with Elwy's own funds. That's in Mr. Beckwith's statement and in the skeleton. Now that's an acknowledgement that the trustee can't himself pay from the monies he's got in the Russian bank because that bank is sanctioned. Otherwise, Miss London is right. And so to make payment to the UK, there have got to be arrangements of some sort involving Elwy, the nature of which, it's got to be said, is exceedingly obscure, but they involve Elwy paying with its own funds. And I stress that. It's Elwy paying with its own funds. It can't be a mere conduit, because if it were, there'd be sanctions issues. So what this means is all the assurances about the trustee being able and willing to pay and so forth count for nothing. That's because the trustee on his own evidence can't pay direct. There have to be these obscure arrangements involving Elwy in order for payments to be made. And so we are in truth looking not to the willingness of the trustee to pay, because he's unable to pay direct because of the nature of his own banking arrangements, but rather to the ability and willingness of Elwy to pay. And about that there's simply no evidence. There's no evidence of their financial standing. And so what the respondents are therefore dependent upon is not the trustee paying, but Elwy, under whatever the arrangements they have with the trustee, being willing and able to make payment on the hypothesis that the appeal has failed. The undertaking has gone, and the trustee's position in England becomes, to put it at its lowest, unattractive. So we say that is a strong additional factor on the trustee's own account of what is going on for ordering security. So for all those reasons, I ask my Lord to impose a condition on the grant of permission. And I do say this is a condition on the initial grant when one looks at my Lord's original order, which adjourned that question to today.
That was certainly the intention.
Unless there are points my Lord's particularly concerned
Thank
about
you.
that I can address further.
Yes, Mr. Davies.
Lord, our skeleton argument makes it clear that there is no application before your Lordship for security for costs. This is an application, in effect, as directed by my Lord under 52.18.2, under which one and a friend must show a compelling reason for attaching a condition to the permission. And my Lord, I think, granted permission subject to that. Now, in my learned friend's skeleton argument, there is no reference at all to CPR 52, whether point 18 or any other sub-rule. And he approaches this application as if it were an ordinary application under CPR 25.15, which it patently is not. And what he seems to do is to suggest that the criteria under 52.18.2 to show, quote, compelling reason, close quote, is coextensive, same as the criteria under CPR 25.15. And with great respect to my friend, it emphatically is not. It is not a coincidence, we would suggest, that there are no authorities, certainly that we can find for what it's worth, where a condition has been imposed at the threshold when granting permission to provide security for costs of the appeal. And the reason for that, I would venture to suggest, is that if permission is granted and security for costs is required, then an application is made in the usual way. There is no such application. Ordinarily, and if I may just borrow my Lord's phrase, security for the debt, for the award, it is the condition. I'm not suggesting for a moment that it's the only condition. The rule is wide-ranging and doesn't have any restrictions. But that is the usual subject matter of the condition, that you bring some or all of the judgment or award into court as a price for having permission to appeal. That is a very different state of affairs from application for security for costs of the appeal, which is prospective. So our position is that if somebody in the position of the respondents in this case wish the court to impose a condition that relates prospectively to the costs of the appeal, that there should be security provided as a condition under 52.18.2, there has to be exceptionally compelling reasons, because it is open to that party to make an application for security in the conventional way.
What difference does it make?
Well, first of all, we have not come to court to argue a case under 25.15. And as you'll have seen in the authorities, and in particular in the case in the Palladium case, well, in none of the cases is there an application for security as such. The question is, should the court impose a condition at the threshold? And this is before there is the ability to make an application, because there is not at that juncture an appeal pending. The rules make a special exception where they allow a party in its brief statement under PD 52C, paragraph 19, to invite the court to impose a condition. That's the only basis upon which it might seek, as it were, a tweak on permission. And that brings straight away into play CPR 52.18 and the compelling reasons. And once you are there, compelling reasons are not the criteria set out in CPR 25.15. And so ultimately, we looked in my learned friend's skeleton argument for any statement of what makes this case a relatively rare case where there should be a conditional permission. And he doesn't address it there. And I didn't hear him address, in his oral submissions to my Lord just now, the discrete and separate category of compelling reason. What is the compelling reason in this case, over and above what you might want to satisfy the court of if this were an application for security for cost of the appeal? So the structure of the rules is such that you can always make your application for security for costs, but if you want to attack permission at the threshold, that's a special case, and hence the authorities. And so all that you have heard from my own friend is the sort of points that he might make on an ordinary application for security. And it's our submission that that's just not enough in terms of paragraph 4 of my Lord's order and bringing my own friend to court to persuade your Lordship that there's a compelling reason in this case.
Okay.
On that footing, my Lord, the points that we make in our skeleton arguments, and if I could just invite you to take it up briefly. We say at paragraph 17, and this is deliberate, it's not, the burden's not on us, obviously, to show a compelling reason. And we've not been able to identify, over and above what would normally be submitted in an application for security for costs, any such compelling reason urged upon your Lordship. All we can do is to say, as we have in paragraphs 17, 18 and so forth, it is set out why on an ordinary application for security it would not be appropriate to give security. But my Lord, no such application has been made, and we have not put before your Lordship any of the authorities on security for costs. The authorities that we're relying on are the authorities which relate to the rule which is in play in this hearing. So we haven't put in we haven't put in any evidence about foreign banks, any witness statement from the foreign trustee, because we say none of that touches the criteria in the rules as interpreted in the various cases, to the fact that there must be a compelling reason. My Lord, the fact remains that this isn't a case where there is an award or a judgment in favour of my learned friends, clients, and there is nothing in that sense to prejudice him. This is an interlocutory appeal which relates to the stay of an undertaking to release some property. And as between now and the hearing of this appeal in early April, there is no prejudice to my learned friends in any event. And he knows, and the court can see, that this trustee is not going to be disobeying court orders in this court because he wants to litigate in the court below the ultimate disposition of the replacement share certificates. The slightly melancholy way in which we come to this court is very much at the outset of the trustee's involvement in this jurisdiction, at a time when he, as it were, the proceedings have not got going in a proper sense, where he would want, in the what we've called the stakeholder or interpleader case in the court below, we would want to participate and to file our evidence to say why we object to the release of the replacement share certificates to the ultimate beneficial owners, in effect, of the respondents. And so, in this appeal, the starting point is that there is no real prejudice in any event to these respondents, which would in some way persuade the court to make the permission to appeal conditional, which is what they ask for. And the points that we make in paragraph 17 are points which substantially support the proposition that there's nothing, as it were, for the court to be concerned about here, which would drive it to impose a condition on permission. Whether one likes it or not, that my client is a professional trustee, and it is appropriate to recognise that in that sense he has a function and duties and obligations, and that those are of a professional nature, and that he is less likely to play fast and loose, and in particular to breach court orders. It's not a killer point, but it is, as it were, the context that this litigant has been invited to come to this country by an advertisement, has been told that he must apply for recognition and has done so, and now wishes to litigate here. And I think it's open to us to submit that the starting point is that he's not likely to be doing that frivolously. He's doing it pursuant to a duty to get in the assets of this estate. And he has confirmed that he will honour any adverse costs order made against him. He's bound to do that. It's suggested that he ought to have given an undertaking of some sort. That's not been requested before. And I've no doubt at all that he'd be prepared to do that if it were thought to be necessary. Your Lordship has seen the rest of the points that we set out in paragraph 17. Just by way of reply briefly on the sub-paragraph E, fifthly, I'm sorry, but he has obtained authority from the Russian court, and he's done that decidedly so that he can have recourse to the Russian estate for the purpose of spending money on legal representation in this country. And that's in evidence, and there's no way one can get around that. It is also in evidence that he has a substantial realised estate. I accept, of course, that it's in Russia, but the fact of all of this, there's nothing shadowy about it. It's all very real. And I'm afraid it is relevant at letter H, and the letter is in the bundle. I don't know whether my Lord looked at it, but my learned friend's solicitors wrote to the bankrupt's solicitors with a view to persuading the Russian court at a hearing on the 13th of December of last year not to allow the trustee to have recourse to the bankruptcy assets for the purposes of his litigation in England. And that, I would respectfully suggest, does show that what is really going on here is just a tactical game. I would remind my Lord that it is the case of my learned friend's clients that they are strangers to this bankruptcy. They're not a creditor. They don't, they say, represent in any way the bankrupt. One would have thought that they would have, with open arms, have welcomed a direction of the Russian bankruptcy court that the Russian trustee can delve into the estate there for the purposes of meeting, in particular, any adverse costs order here. But they attempted to persuade the Russian court to the contrary. My Lord, as for sanctions, this has been dealt with comprehensively in evidence, and I know my Lord has read our skeleton argument, and we deal with it in paragraph 20A. The fact is that all that they can direct or level at us is that we have a bank account, that is to say, my client, Mr. Vesnin, has a bank account with the Credit Bank of Moscow, which is sanctioned. That is the beginning and the end of the point on sanctions. And my Lord, everybody knows that perfectly lawfully, if somebody wants to, in the position of Mr. Vesnin, wants to move assets out of Russia, then he can do so. He just doesn't need to use a sanctioned bank. My Lord, the compelling reason test has, so far as we are aware, never been applied to the question of security for costs. We have, for what it's worth, looked through the authorities. We've looked at great deal of authorities. We've never come across such a thing. My Lord has vastly more experience than I do of these things, and it may well be that, as it were, it happens. But I hope you don't mind me at least submitting that we found no jurisprudence on this.
Well, that's a perfectly valid submission to make, and I'm grateful to you for the industry in looking.
And my Lord, I think I'm repeating myself. I'm going to sit down then. But the reason for saying that is that it's not surprising, because what happens in real life is that an application is made under 25.15 if and when permission is made.
Very good.
Well done, obliged.
Thank you. Mr. Edwards, I needn't trouble you to reply. By order dated the 14th of January of this year, sealed on the 15th of January this year, I granted the appellant permission to appeal against an order of Mr. James Morgan KC dated the 8th of November 2024, but subject to determination of an application by the first and second respondents for a condition to be imposed on the grant of permission to appeal that the appellant provide security for costs. The basis upon which I understood that application to be made at that time was that the first and second respondents, who I will hereafter simply refer to as the respondents, were inviting the court to exercise its power under Rule 52.65 and Rule 52.18(1)(c). That was subsequently confirmed in evidence filed by the respondents. In those circumstances, counsel for the appellant submits, in my view correctly, the correct criterion to apply to the application is that specified in Rule 52.18(2), namely that the court will only exercise its powers where there is a compelling reason to do so. What amounts to a compelling reason must of course be judged by reference to the nature of the condition which is sought to be imposed. In the present case, as I've explained, the condition that is sought to be imposed is one of security for costs of the appeal. It is quite true that, as counsel for the appellant points out, the respondents could have simply made an application under Rule 25.15, and in circumstances where they have not taken that course, they must accept the burden of demonstrating the compelling reason. Nevertheless, it doesn't seem to me that that detracts from the proposition that what may be a compelling reason in one context would not necessarily be a compelling reason in another context. Here, we are concerned with security for costs. It's not necessary for present purposes to explain the rather complicated background to the appeal. It's sufficient to say that the respondents hold a substantial minority shareholding in a company called Eurasia Mining PLC. They lost their share certificates in an office move, and Eurasia declined to issue replacement certificates. That led to them issuing proceedings back in December 2021, seeking to compel Eurasia to issue replacement share certificates. Subsequently, the appellant became party to the proceedings. Here, the appellant is the trustee in bankruptcy of a Mr. Dmitry Ananayev, and it is the trustee's contention that the shares in question were beneficially the property of Mr. Ananayev, with the result that they form part of the bankruptcy estate. that is disputed by the respondents. There was a hearing before Mr. Morgan, the upshot of which was that he made an order releasing Eurasia's solicitors from an undertaking they'd given to hold the replacement certificates with effect from the 24th of January of this year. And it is against that order that the appellant appeals, and in the meantime the release of the undertaking has been stayed. So far as the basis for the present application is concerned, it seems to me that the respondents are justified in contending that there is a compelling reason to impose a condition on the grant of permission to appeal that the appellant provides security of costs for the following reasons. First, there is no dispute that, with the exception of the disputed shares, the appellant has no assets within the jurisdiction, and certainly no substantial assets which could be readily realised at the suit of the respondents in order to satisfy a costs order. Secondly, the respondents have served unchallenged expert evidence demonstrating that there would be substantial difficulties enforcing any costs order against the appellant in Russia. Thirdly, the respondents' potential difficulties with respect to enforcement are, if anything, confirmed by the appellant's own evidence on this application. The appellant points to the fact that he has satisfied an order for the payment of £40,000 by way of costs on account, pursuant to Mr. Morgan's order. It is the appellant's own evidence, however, that because the Russian bank with which he banks is sanctioned, the mechanism that had to be employed in order to comply with that order was that the sum in question was paid by the appellant's Russian solicitors, referred to as ELWI, from a different bank account and using EWLI's own funds. That seems to me to be a pretty graphic illustration of the potential problems and obstacles that may face the appellants were they to need to refer to enforce any costs order in Russia. Against those points, the essential point that is made on behalf of the appellant is that he is a professional trustee, which I entirely accept, and that there is no reason for the court to think that he would not voluntarily comply with any costs order made against him. I do not consider that that is the correct question. The correct question is not whether he would voluntarily comply, but whether, in the event of non-compliance, any costs order could be enforced against him. Apart from everything else, as the respondents point out, it cannot be regarded as certain that the appellant will remain in office when any costs order is made and comes to be enforced. He could be replaced by a different trustee. I fully accept that the appellant has so far not defaulted upon any court's order against him. But for the reasons I've given, that does not seem to be particularly relevant. The further point is made by the appellant that he has obtained authorization from the Russian bankruptcy court to treat costs in the English proceedings as an expense of the bankruptcy, and moreover, the bankrupt estate currently has realised assets of around £4.5 million in Russia. That, as it seems to me, is a point against the appellant. In circumstances where he has the authority of the Russian court to treat costs in the English proceedings and expense of the bankruptcy, and moreover has substantial realised assets, it seems to me that there is no good reason for the appellant to decline to use some of those assets in order to provide security for costs. This is not a case where of a trustee in bankruptcy who is in difficulty because he cannot fund litigation out of realised assets. To the contrary. Lastly, points are made about the behaviour of the respondents. It's not necessary for me on this application to express any view about the respondents' conduct. It suffices to say that insofar as the appellant has any valid complaint in that regard, it may possibly lead to appropriate orders being made against the respondents. For example, it may, and I'm not prejudging the question, it may lead to the respondents being required to provide security for costs for their appeal, which they are presently attempting to bring against a subsequent order made by Chief ICC Judge Briggs, for which they are presently seeking permission. So far as the present application is concerned, I see nothing that leads to the conclusion that the court should refuse to exercise its discretion to require the appellant to provide security for costs of the appeal. For all those reasons, I will make an order as invited by the respondents. The respondents sought security in the amount of £170,000, that being calculated on the basis of 65% of their estimated costs of the appeal. That seems to me to be a little on the high side for what is in essence a procedural appeal, but I will make an order for security for costs in the sum of £150,000, and the method and timing of that I will discuss with counsel now. So, Mr. Davies, how long do you want, and what methodology would you propose?
Would your Lordship give me a moment?
Sure.
My Lord, one of the difficulties that we have is that there is an outstanding order for costs that Chief ICC Judge Briggs has made for £160,000, which was payable on the 31st of January, which has not been paid.
Right.
And we would be anxious for that breach to continue, to avoid that breach continuing and having to pay a further £150,000. Because it is a plain vanilla breach of the order. And it would seem unjust in those circumstances for us to transfer from Russia £150,000 to meet the order of this court in circumstances.
That seems to be an attempt to re-argue the merits of the order. What I've asked you is how much time you want to comply with my order and by what method you're proposing to comply with it.
My lord, could I ask for 21 days?
Right, and do you have, I mean, it may be that you just don't know how you're going to deal with it at this
I don't.
stage. But the point of asking the question is this, that as you know, the default is payment into court.
Yes.
But to payment into court can cause administrative difficulties.
Yes.
And from the payer's perspective, it is sometimes preferable for an alternative methodology. So what I would be minded to say, so far as methodology is concerned, is payment into court or such other method as may be agreed between the parties, unless you've got anything concrete you wish to discuss at this stage.
I can see the sense of that, my lord.
All right, very good. What about 21
I couldn't
days?
possibly oppose that. What I was going to say was, my experience is the same, that payment into court can be a real problem. And a practical middle ground can be a payment into a solicitor's client account
Quite.
on a solicitor's undertaking to hold to the order of the court, which
Quite.
is as good as money's in court. So if my lord were minded to say payment into court, payment into solicitor's client account on a solicitor's undertaking, or such other means as may be agreed in writing,
That would seem to be a helpful way forward, Mr. Davies, yes?
Lord, yes.
Yeah. Very good. And you've got no objection to 21 days?
my lord, no, I can't do that.
No. Very good. Well, that's the order I make.
That brings us to the costs of today.
Yes.
I don't know whether my lord is prepared to get into the weeds of that, or simply to say they ought to be assessed if not agreed.
Well, I saw the statement of cost and it struck me as a bit on the high side. So I'm, of course, willing to undertake a summary assessment, but it's up to you.
Well, I think I'm very conscious of the time and the amount of my lord's time we've already taken up with this. Perhaps a sensible thing to do is to invite my lord to say I should have my cost of the application to be assessed on a standard basis, if not agreed.
That's not opposed. I'll make that order. Thank you both.